Verbal and written statements are commonly offered at hearings and trials to prove facts at issue in a case. Courts are required to exclude certain statements from evidence when they were made by parties not present to testify at the trial or hearing. These statements are referred to as hearsay. The types of statements that are excluded as hearsay include a person's oral assertion, written assertion, or nonverbal conduct that is intended as an assertion. A head nod, for example, is nonverbal conduct that is also an assertion. The party that originally made the statement or assertion that is being offered as evidence is referred to as the declarant. Hearsay is 1. A statement that the declarant makes other than while testifying at the current trial or hearing, and 2. That is offered to prove the truth of the matter asserted. Anytime a witness testifies as to what another person said and offers it as proof that what the other person said is true, then that evidence is being offered to prove the truth of the matter asserted. For example, let's say that in a family law case, Henry wants to testify that his wife's mother, Mother May, stated that she saw the wife, Wendy, hit her child. Since Henry is testifying as to what Mother May said, the testimony could be hearsay. If Henry is offering Mother May's statement as proof that Wendy hit their child, then it's hearsay. Henry is not the proper person to testify as to what Mother May said. Mother May should herself testify as to what she observed. On the other hand, suppose Henry is offering Mother May's statement to show that Mother May and Henry communicate regularly about the child. For example, what if Henry wants to support his claim that Mother May is an appropriate temporary guardian for the child, and therefore wants to establish that she takes an interest in the child and discusses the welfare of the child on a regular basis. Henry is no longer trying to prove that Wendy actually hit the child. Since Henry is not offering this statement as proof what Mother May said is true, the statement does not meet the definition of hearsay. It's being offered essentially to show that the conversation took place. The substance of the conversation is not really relevant to that point, and it's not critical to determine whether the statement that Wendy hit the child is actually true to establish what the testimony is trying to prove. Therefore, this statement is not being offered for its truth value and is not hearsay. One nuance to the hearsay rule is that statements made by the opposing party in the current case are not hearsay. These statements are referred to as admissions of a party opponent and are admissible in court so long as the admission is being used against the opposing party. Thus, if Wendy ever admitted to hitting the child in the previous case, Henry could introduce Wendy's admission into evidence and use it as proof that she did in fact hit the child. This, incidentally, is why confessions made to police officers by criminal defendants are admissible at trial, even though technically they're hearsay. Many exceptions to the hearsay rule exist to allow certain statements to be admitted as evidence. Some exceptions apply only when the declarant is not available to testify as a witness. However, most exceptions apply regardless of whether the declarant is available. Thus, for example, any of the statements that meet these exceptions are admissible even when the witness is not the declarant, and even when the declarant can be theoretically brought to court to testify. Let's take a look at some of these exceptions. Present sense impressions are statements that explain an occurring event or condition. These statements are made while the declarant perceives the event or condition, or immediately thereafter. For example, a witness may properly testify to being a passenger in a vehicle and hearing the driver say, "I'm driving way too fast right now," because this statement was made while the driver was perceiving the driving. The next exception is an excited utterance. An excited utterance is a statement relating to a startling event or condition made while the declarant was under stress of excitement that it caused. A witness screaming, "Oh my gosh, that car ran a red light," directly after observing a car accident is an example of an excited utterance. However, if the same witness makes this same statement 5 days later, for example, then the statement was not made under the stress of excitement from the accident and is therefore not an excited utterance. The third exception is a statement of a then existing mental, emotional, or physical condition, which expresses the declarant's then existing state of mind. The statement may express motive, intent, plan, emotion, sensory perception, or physical condition. This exception does not apply to a statement expressing a memory or belief. Just like the present sense impression and excited utterance exceptions, a statement of a then existing mental, emotional, or physical condition must be made close in time to the related event or condition. A statement such as, "I am scared," expresses a state of mind. The statement, "I remember being scared when the dog approached me," expresses a memory. Therefore, the first statement is considered an exception to the hearsay rule, while the second is not. These first three exceptions are collectively sometimes known as the res gestae exceptions. It's as though the event is speaking through the statement, since the statement is being made at the time that the event is ongoing. Exception 4 is a statement made for medical diagnosis or treatment. This must satisfy two requirements. First, the statement must be made for and reasonably pertinent to a medical diagnosis or treatment. Second, the statement must describe medical history or past or present symptoms or sensations, their inception, or their general cause. This exception is broad, and the statement does not need to be made directly to a medical provider, nor does the witness need to have medical training. Witness testimony that the declarant stated, "I have a back pain, and my back's been hurting for about 5 years," to a hospital staff member, for example, falls within this exception. The next exception is made for records of regularly conducted activities, and is commonly known as the business records exception. This exception is used to admit written statements of an act, event, condition, opinion, or diagnosis. The record must be made at or near the time of the act by someone with knowledge of the information in the record. The record also must be made and kept as part of a regularly conducted activity of a business, organization, occupation, or calling. Unlike the other exceptions we've discussed so far, in order to admit evidence under this exception, the testifying witness must be someone who's responsible for keeping the records, or be otherwise qualified to testify as to how and why the records were kept. For example, in a mortgage foreclosure case, a lender may want to admit mortgage documents into evidence. The mortgage documents themselves would be considered hearsay, because they were written by somebody not here testifying in court right now. They're hearsay, that is, unless the lender provides an employee who has the job of maintaining the mortgage records. The employee must be able to testify that the record was made near the time of the mortgage, or near the time that the mortgage was created, and that the record was kept as part of the regular course of business. Police reports are another common example of a business record. However, a statement from a witness contained within a police report may not necessarily be admitted simply because the report itself qualifies as a business record. This presents the problem of hearsay within hearsay, where the hearsay document, or the report, which is admissible, contains another layer of hearsay, which is the statement from the witness that was written down by the police officer. Each layer of hearsay will need to fall within an exception. For example, a witness may make a statement in a police report while still under the excitement of the event covered in the report. In that case, the police report can be admitted as a business record, and a statement from the witness can be admitted as an excited utterance. Until now, we've been discussing exceptions that apply whether or not the witness is available to testify. There are some exceptions that require the unavailability of the declarant in order to work. Regarding these exceptions, a declarant is considered unavailable when one of the following applies. 1. A court rule or privilege prevents the declarant from testifying. 2. The declarant refuses to testify after a court order has been issued. 3. The declarant testifies to not remembering the subject matter. 4. The declarant cannot testify because of death, infirmity, or physical or mental illness. Or 5, the declarant is absent from the trial or hearing, and the party seeking to present the declarant has not been able to ensure the declarant's attendance. We will discuss 2 of these exceptions. The first exception requiring unavailability is for statements made by the declarant under the belief that death is imminent. These are commonly referred to as dying declarations. The declaration should be about the cause or circumstances of the declarant's death. If, for example, a victim is shot in the chest and yells, "Brian shot me!" this statement may be a dying declaration, because the declarant could reasonably believe that death was imminent after being shot. Finally, a statement against interest of the declarant is another exception that can be used when the declarant is unavailable. This refers to a statement that is so contrary to the interests of the declarant that it must be true. The statement can expose the declarant to liability or jeopardize a financial or ownership interest. The idea is that no reasonable person in the declarant's position would have made the statement unless the person believed the statement to be true. Such a statement could include a driver apologizing to another driver for causing an accident, or the declarant's admission to another person that the declarant owes that person money. Since the statement exposes the declarant to liability, a reasonable person would not make that statement unless believing it to be true. The common thread throughout the exceptions is that hearsay is allowed when we have an independent reason to believe that the declarant's testimony is true. When there is no such independent confirmation of the declarant's testimony, we do not allow the declarant to, in effect, testify through someone else's mouth, and thus avoid cross-examination and credibility assessment by the jury. Where there is a good reason to believe that the declarant's statement is true, a cross-examination would be moot, and a credibility determination is unnecessary. Therefore, there is no danger in allowing the hearsay to be admissible.